Oh, we've got the thumbs up. Great. So good morning, everybody. Welcome, very warm welcome to Myerson this morning. Welcome to those of you in the room. And also, we've got around 150 people logging in to watch this morning as well, remotely. So welcome to all of you as well. My name's Jo Evans, and I'm head of the employment team here at Myerson. And I'm joined today on our tall chairs by Jo Henderson, who's also a partner in our employment team, and Patrick Byrne, who's an associate in our employment team as well. We've also got the rest of the employment team around the room, so they will speak to you afterwards as well. A couple of housekeeping points before we kick off. We haven't got a fire alarm scheduled for this morning, so if the fire alarm does go off, it's real and we will point you in the right direction to get to safety. Please make sure your phones are switched off during the seminar, and we are recording the session this morning, just so you're aware of that. We will circulate to you the link after the session through our Myerson YouTube channel, as well as the slides, so you can watch again if you would like to, double check any points you're not sure about, or share it with colleagues as well if that would be helpful. So, there we are, the team that's talking to you today, and this is our agenda for today. We're using our 10 hot topics format backed by popular demand, because we get really good feedback about picking out top 10 important points for you to be aware of. You'll see there's a bit of COVID in there. We feel we still need to talk about that a little bit, but lots of other topical content as well for you. We want you to leave today feeling up to date, feeling like you know what's going on, what the most important things are that are going on and what's coming up as well. So hopefully we can achieve that for you today. Our plan is to talk to you for about an hour between us. I'll deal with the first 3 points on the agenda. Jo Henderson will then talk to you about the next 3, and then Patrick is going to pick up the final 4 points for you. And as I say, that should take around about an hour, and then we've got plenty of time at the end for questions as well. For remote attendees, because we're running this in a hybrid format, for those people watching remotely, if you've got questions, please use the chat function and stick your questions in there, and we'll come back to you with answers to those after we've finished. But for those in the room, gather your questions and we'll talk about those at the end. So let's start with our first hot topic today, which is working with COVID. We've obviously had quite a journey over the last 2 years. Let's not talk about it all over again. We've dealt with lots of different regulations, clearly, which has impacted businesses in all sorts of fundamental ways. But we're now, as I'm sure you're aware, living with COVID. That's the new official guidance and government approach, which is fine, but what does that actually mean as an employer, and how do you manage your employees? Because obviously COVID is still circulating, COVID is still out there. So to talk about that a bit, first I want to look at the path to get to where we are today, because there's been some significant changes over the last 3 months or so. As a reminder, January was the point at which the requirement to wear masks was removed. February, the requirement to self-isolate was removed, although the guidance is still to self-isolate if you have got COVID. And March, the removal of our COVID-19 sick pay arrangements, which, if you remember, that provided for sick pay to be payable from day 1 rather than day 4, and payable to people who are well but having to isolate. So that was removed in March, giving that the issue around, well, if I'm not going to get paid, I'm going to go to work then, issue. Beginning of this month, the government produced lots of new guidance. We've had lots of guidance, haven't we? But lots of new guidance, particularly around living safely with respiratory infections, including COVID-19. So the new approach is very much, how do we manage our employees who are ill, whether that be with COVID or any other respiratory illness? It leaves employers to decide themselves how to approach sickness. You no longer have that legal regime that you have to comply with. You have to choose and select the best way to deal with your employees. But you've still got a statutory duty to keep your people safe and healthy. So it's an interesting time and perhaps a challenging time to think about how do you, as your particular organisation, deal with that situation. So some of the main areas that crop up here on this slide, just to talk through really. Firstly, masks, as I say, no legal requirement to wear masks. You can't insist on people wearing masks. However, that might still be something that you feel is reasonable to ask your employees to do. It depends on your work setting. It depends whether you've got a large group of people in close proximity indoors. It might still be a very sensible thing, an important thing to do to keep people safe. Likewise, testing, no legal obligation to test at all, but within your organisation, you might feel that certain roles, certain work areas, people being asked to test continues to be something that's important. Of course, we're now at the point where if that happens, you're going to have to buy the tests for your employees because they're no longer free. Touching on respiratory illness symptoms, so the government guidance lists 10 different symptoms that could indicate respiratory illness, including COVID, ranging from the persistent cough to the temperature to the runny nose and feeling a bit sick. And the government say you've got to decide yourself how you deal with employees who have any of those symptoms. So arguably, a runny nose, you could have to say, well, that's a risk of infection, so work from home. That might be the right approach for your organisation. For many, that's not going to be realistic at all, and you'll have most of your workforce off most of the time if any symptom involves people not coming into work. The government do say there's two particular scenarios where you should take it more seriously. So somebody who isn't well enough to work obviously shouldn't come to work, as we've always had that situation, haven't we? And also, if someone's got a temperature, that's singled out as the symptom that the government feel is the most important and perhaps carries the highest risk. So if somebody's got a temperature, you take that more seriously than some of the other symptoms. But you've got to look at each situation, you've got to look at your workplace and think about how will you deal with people. What policy do you want to have in place? Do you want to ask people to wear masks? Do you want to ask people to stay at home? Do you want to ask people to work in a more remote part of the business? How do you want to handle people who have got symptoms? You do still need to think about your vulnerable people. Pregnant, old, underlying health conditions, there's still a need to think about them because they're the people who are more likely to be at risk of coming into contact with people who are ill, and the immunosuppressed, who are the highest category of risk. And those people, there's still guidance to them that they should work from home if they feel that that's how they want to proceed. So if you have got people in that category, they can say to you, I'd like to work from home and continue to work from home, and you should be taking that very seriously. The government says that we should also still be thinking about keeping workplaces clean, particularly clean. We need to think about ventilation, and we as employers need to think about supporting our staff and encouraging our staff to get vaccinated. Those are things that should be part of what you do in your organisation. There's no longer a requirement to have a specific COVID-related health and safety policy, as there was. That's gone now. But, as I say, you have this overarching obligation to deal with health and safety, and respiratory illness, including COVID, is part of that and should be part of that. So have a clear policy, make sure it's communicated to your people, and make sure you follow it, is the conclusion, which for those who come to these sessions know that that's often the conclusion to each of these topics. But think about your particular workspaces, think about the risks, think about your people and how to mitigate risks, and make sure you have a policy that follows the ongoing government guidance. The other thing to remember, of course, is this continues to evolve. The COVID rates continue to change. We will still have variants, I'm sure. So it is something you've got to keep under review. What's appropriate today might not be appropriate next week. Will be different to what was appropriate 3 weeks ago. So you have to keep looking at that. If you've got someone who actually has a positive COVID test, what do you do with them? We've had quite a lot of those recently. Hopefully the numbers are going down again now, but who knows? If they're unwell, then it's straightforward. They're unwell and they're ill, and you treat them in the same way as you treat anyone else who's unwell. But if they are positive but able to work, then what do you do? Firstly, as a policy, encourage reporting, because that's the best way of protecting your people, that people feel that they can come forward and say that they've had a positive test. No obligation to tell you, but encourage your people to come forward. If people can work from home, it's easy. They work from home, don't they, whilst they have COVID. And the guidance is they should avoid contact with others for 5 days, and the vulnerable for at least 10 days. So working from home is an easy solution there. If they can't work from home, they can't do their job remotely, then is it safe for them to come to work? Can you safely have them in your work environment? Does wearing a mask or putting them in a remote part of the business work such that they can actually safely work without causing concern for others? If they can, great. If they can't, then they need to stay home and they can't work, then you're going to have to pay them to sit at home. And that's the backstop position until they're testing negative and able to come back again. So as I say, keep it under review and keep watching the information, but that's generally how to deal with it in terms of managing COVID. So next topic, related, long COVID. So this is the new challenge, and to put it into context, we've had statistics from the ONS last month saying that 1.7 million people have long COVID now, so significant numbers of people in the workplace are suffering with long COVID. Technically, long COVID is where you are still suffering with symptoms of COVID for more than 4 weeks after having had COVID. And it comes in all shapes and sizes, and some people can have it in a minor way and some people can have it in a very, very serious way that lasts for a long time. The stats say 1.1 million people say their day-to-day activities are affected, and 300,000 say that they are significantly impacted by long COVID. There have been campaigns, and you might have seen these, to class long COVID as a disability. So the TUC and the Equality and Human Rights Commission have both said you should think about your employees who have long COVID as disabled. Now, that's not technically, legally the case, but it's something that is being lobbied for. There's also a campaign by Unison to require employers to discount COVID-related absence or self-isolation absence from any performance management or sickness management processes. So we're moving forward in this kind of situation, but for now, you follow your normal sickness absence process as you would with any other sick employee. You provide support as you would with any other sick employee as well. And at the moment, it's not technically a disability that gives disability discrimination protection in itself. Having said that, there will be people with long COVID who are technically disabled. The test is always, what is the definition of disability? And that is, as on the slide, somebody who's got an impairment with a substantial long-term adverse impact on their day-to-day activities. So if you've got an employee with long COVID who you think is near or over that line, then they are protected by disability discrimination legislation. So don't discriminate against them, and consider reasonable adjustments for them, which perhaps you should consider for anyone with long COVID as well. The other thing to just bear in mind when we're talking about discrimination is it's well recognised now that those who get long COVID are disproportionately older people, ethnic minority people, or women. And therefore, if you are doing anything that has an impact on people with long COVID, you could be falling towards the territory of sex discrimination, race discrimination, age discrimination as well. So think about that as well. Practical tips. One of the challenges with long COVID is it affects people in very different ways. It fluctuates, people get better, people get worse, their symptoms change over time. And it's something that is very new and there is not a lot of knowledge about it. So anything you can do to build knowledge so that you can provide the best possible support for your employees who are suffering with long COVID is a sensible thing to do. Talk to your people, find out how they're feeling, find out what they're suffering, find out what their doctors are saying about how they're doing and how they're likely to progress with the illness. That way you can give the best possible support, you can manage any issues as best as you possibly can. There are lots of support groups out there for long COVID sufferers, so signpost to those, because if someone's suffering a new and strange illness, if they can talk to other people who are going through that journey as well, then that can be really helpful. Remember occupational health, get their advice on adjustments and prognosis, and keep speaking to them, and just be open-minded to what adjustments can you make for people. The obvious change of hours, change of duties, change of work location, let them work from home, but be mindful that again has to be flexible, because you might have somebody who can work well in 1 week but really can't work well in the next week. And of course I appreciate all of this comes with difficulty and you need to get jobs done, so it's managing all of that, but taking all of these things into account, because ultimately there's a disability discrimination risk if you're not handling these situations properly. Okay, so my third topic is working overseas. And I've put this one in because we're asked a lot at the moment by clients about this who have employees who want to work overseas more than ever in the past. Obviously, during the pandemic, workforce was dispersed around the country, but also to different countries. People got an idea about working remotely and well, if I can work remotely, why don't I work abroad? And the south of France seems quite attractive. Why don't I do that? Or wherever it is, I've got family connections wherever. So we are getting lots and lots of queries about how do we best handle this. And so wanted to just touch on a few points around this today. Of course, you may want to accommodate overseas working. It might be something that you're very happy to accommodate. It might help you with your recruitment by being able to have people working abroad. But there are lots of legal and practical considerations. So I just wanted to highlight a few of those today. Firstly, and most importantly, make clear to your people that this does require pre-approval. There does seem to have been a slight shift in expectations of employees who feel that they can, because they've been at home for a long period, they can determine where they work from, and that could be anywhere in the world. Well, no, they've been at home because we've been in a pandemic, but unless there has been a communication that you can work where you like on a permanent basis, the expectation is they will come back or they will work in accordance with your hybrid arrangements or however you're putting arrangements in place. So the idea of working abroad clearly would need pre-approval. You need to be very clear that it's legally possible. It's obviously not the case that you can just rock up in a random country and start working. You need to make sure that that is legally something that can be done depending on the particular person in the particular country. You need to think about whether, if someone does go and work abroad for a period, they can get back and continue to work in the UK. If they're not a UK passport holder, whatever immigration status they had, you need to check that that's not undermined. Lots of practical questions as well. Can they do their job abroad? How are you going to communicate? Delegation, supervision, how's that going to work? Time differences, additional costs, who's bearing those, employer or employee? Health and safety, you've got your obligation to keep people safe under UK law. There may well be local law health and safety implications as well. Confidentiality, how do you keep information confidential if you're dealing with somebody the other side of the world? What if they're data processing? That data is then being moved from the UK to a different country. That you can't just do that, you have to have the correct protections in place for that data. So lots to consider. From an employment rights point of view and tax point of view, it's getting those things straight too. So everyone in the UK has UK employment rights. We talk about unfair dismissal and discrimination and all the other rights that we deal with on a day-to-day basis. If someone is based abroad, they may well pick up local employment rights as well. They may have an entitlement to local benefits, a local pension scheme, medical plan. Their medical insurance that you offer in the UK might be impacted and might be invalidated, so you would need to check that. Probably you will continue to need to pay social security payments, national insurance payments, normally has to be paid for up to a year if people move abroad. And likewise income tax you probably need to pay, but depends where they go and how long they go for. If they go for a relatively long period of time, you could face having to pay corporation tax abroad on the profits of your business. So lots to think about, as I say. Take advice. Short trips are easier to manage than long trips. The longer they are, the more complex it becomes. And it can be done, but you need to plan and think about it and get all the ducks in a row. So that's what I wanted to cover. I will now hand you on to Jo, who will talk to you about topic 4.
Morning everyone. I'm going to pick up the next 3 topics on our agenda, which are pronouns in the workplace, hire and fire tactics, and also holiday pay. Not in that order, I realise, but the first one I'll talk about is the practice of using pronouns in the workplace, which is a practice that we're beginning to see, people sending emails where they are making an expression of their gender identity. I prefer to be referred to as she or her or he or him on their emails, and in other places too. So what's the legal position to consider when we see that? The legal point is that those people who are trans, non-binary or gender fluid are protected under the Equality Act under the label of the protected characteristic of gender reassignment. I think it's well accepted that the gender reassignment term is an outdated term and the better term is trans. It is unlawful to discriminate against a trans person under the Equality Act. One of the interesting cases in this area is the case of Miss Taylor and Jaguar Land Rover. Miss Taylor was an engineer, and she declared to Jaguar Land Rover that she was either non-binary or gender fluid, and she was referred to at work as it and also suffered abuse, a very hostile environment. She made a claim to the Employment Tribunal, and Jaguar Land Rover's position was that she wasn't covered by the Equality Act. But it is clear, in fact, that people who are non-binary or gender fluid are also covered under the legislation. And so any person who is transitioning away from the sex that they are assigned on their birth certificate to a different gender identity will be covered under the Act. And that's wherever that journey ends. They might find themselves with a different binary gender identity, male or female, or they might be non-binary or fluid, but they will be covered under the Act. And so to refer to somebody in the wrong gender, so misgendering, might be harassment. Also, dead naming might be harassment, where you refer to somebody by their previous gender or their previous identity. And that can amount to discrimination and liability. So in the case of Jaguar Land Rover, they were caused to pay £180,000 in compensation to Miss Taylor, and also to comply with recommendations of the Employment Tribunal to look very closely at their inclusivity and diversity policies. And I think what that case highlights is the complexity of this area and also a lack of awareness. Very recently, the case is a 2020 case about the issues. As awareness grows, what we're starting to see is employers adopting a policy of perhaps encouraging employees to make a statement or expression around their gender identity on emails, perhaps on social or website profiles, and also even on name badges, for example. And having a policy like that obviously has its advantages. What it does is it provides support to the trans community. It normalises the conversation around gender identity by raising awareness and acceptance of the different gender identities. So it's a good policy, and obviously it avoids embarrassment. It avoids other colleagues making mistakes by misgendering, referring to people in the wrong gender identity, and perhaps inadvertently giving rise to liability for harassment or discrimination. So it's perhaps a good policy to have, but there is a dilemma because it's not necessarily a good policy to have. It can cause a lot of embarrassment. Trans people may have just begun their journey in transitioning, and they may not yet be ready to out themselves as a particular gender identity. They may want to conceal their identity for lots of different reasons. It might also be the case that trans people or non-trans people object to revealing their gender identity. It's a well-known fact, a statistical fact, that women in the workplace, people declaring their marital status in the workplace or their gender identity, might suffer discrimination because they have made it clear what their gender identity is. So ironically, making the declaration might cause discrimination. So there are reasons also not to reveal your gender identity or to adopt a policy in the workplace where that is required. I think the advice is for employers that it's okay to have a policy to encourage people, if they would like to make a statement or expression of their gender identity, but it would not be okay to require it. If you are going to adopt a policy, make sure it's appropriate to your organisation. Make sure that there's awareness and understanding before you introduce it, which will involve education and perhaps a shift in culture for a lot of organisations. Some other practical tips in terms of how employers should approach the use of pronouns in the workplace. Irrespective of policy around emails or workplace profiles, it's a good idea to begin to encourage neutral language in the workplace, particularly in meetings. So imagine a meeting where I walk in and say, "Good morning, ladies and gentlemen." That might exclude and offend a number of people in the room who haven't identified with one of those genders, being a binary male or a binary female. It's far better that I address the meeting, "Good morning, everyone," which is more inclusive and more supportive of the community. It's not a difficult step to take, but perhaps an important step to take to make sure that your workplace is inclusive. Similarly, policies within the workplace should be based on a neutral language. So rather than using terms such as he or she or his or hers, you would use perhaps the singular they, or perhaps include comments like all staff or everyone must in your policies, but not referring to binary genders, because again, that might be exclusive. And this is all about using language and pronouns in the workplace and making sure that we don't make stereotypical assumptions about someone's gender identity. But there are other practical steps as well, of course, to ensure that you have an inclusive workplace, and that might be adopting a neutral dress code, and also, if it's necessary, to offer neutral facilities such as toilet facilities if you have trans people in your workforce. It's not a completely straightforward area. What about people within your workforce who have beliefs or conflicting beliefs with the position of a trans person? That is an area that is becoming litigated. A particular interesting case is the case of a Christian doctor who was responsible for health assessments for employees within the Department of Work and Pensions in Scotland, and he conscientiously objected to the idea that a person could transition away from the sex that they were assigned on their birth certificate, and his objection meant that he refused to address his trans patients by their preferred pronoun. He was dismissed for his approach, and an employment tribunal found that that dismissal was not discriminatory because his views were not compatible with human dignity. Since that case, there have been a number of other cases, and two in particular, where the Employment Tribunal and also the Employment Appeal Tribunal have found that to hold a belief that it is not possible to transition away from the biological sex or the sex assigned to you on your birth certificate is a belief that is worthy of respect in a democratic society. So we do have a conflict here, and it's an area of flux. The EAT is about to consider these issues again. In fact, they've heard the cases in March, but we haven't yet had the decisions, which might provide us with some more clarity. But in the meantime, the advice to employers is that there may be a conflict between the protected characteristic of having a religious or philosophical belief and the position of a trans person who also has a protected characteristic. And it may be that we have to tolerate the views of certain people in the workforce who are not appreciative of the position of a trans person. What's also clear from the case law, though, is we might have to tolerate people holding those beliefs, but we don't have to tolerate people who manifest those beliefs by taking adverse or derogatory steps toward which impact the trans community. So it's a difficult balancing act, and I think very specific to a workplace and the individuals involved, but certainly an issue to consider and an issue to keep an eye on in the case law, because I think we will see some further clarity on that soon. I'll move on to my next topic, which concerns holiday pay. Holiday pay has taken up a disproportionate amount of employment tribunal time in recent years, and it continues to take up time in the senior courts in the UK. And we have had an important Court of Appeal decision earlier this year. So just to go backwards a little bit, quite some time, you'll remember that the leading case that we were all concerned about for some time was the case of Bear Scotland, and that was the case that established that holiday pay must reflect normal pay and so must be calculated including a reference to overtime and commission as well. And that led to lots of claims from groups of employees for top-up holiday pay, but also lots of claims from misclassified workers who were misclassified as self-employed, so they'd had no paid holiday and had substantial claims for holiday pay. The claims under Bear Scotland were claims that were made as unlawful deductions from wages claims. And the reason that the claims were framed in that way was because the remedy under the working time regulations is a defective remedy to some extent, in that if you make a claim for holiday pay under the working time regulations, you have to make a claim in respect of each non-payment. So it's completely impractical to raise a new employment tribunal claim each time you've not been paid for your holiday. And so what happened is the practice became to raise claims under the unlawful deductions from wages sections of the Employment Rights Act. Over time, that became a more limited type of claim because the rule in Bear Scotland was that you could not claim for holidays where there had been a break between periods of holiday of more than 3 months, and so that broke the continuing series of claims that you were able to claim for under the Employment Rights Act. And also we saw regulations come in 2015 that limited the scope of unlawful deductions from wages claims to giving a backstop of 2 years. So that was Bear Scotland. It's not a complete analysis of the law on holiday pay because it doesn't consider the remedies under the working time regulations. The next case to recall is the case of King and Sash Windows. So this was the case where Mr. King was a worker and he had been deterred from taking holidays at all during his employment, and his case was ultimately referred up to the European Court of Justice. He was a worker and the European Court of Justice decided that where there had been a deterrent and he had not been allowed to take his holidays, his holiday entitlement accrued from year to year and was carried over into each new year. And that would be the case wherever an employer has not made it clear that there is an entitlement to holiday, encouraged that holiday to be taken, and the holiday has still not been taken. So the bar is really quite high. Workers can accrue significant amount of holiday over a number of years. We never got to hear the end of Mr. King's story because that case was settled out of court. So fast forward to 2022 and the case of Mr. Smith and Pimlico plumbers. Mr. Smith has been a thorn in the side of Pimlico plumbers for some time. Firstly, taking them all the way through to the Supreme Court to establish his status as a worker rather than a self-employed contractor. And now his most recent battle has been in the Court of Appeal about his entitlement to holiday pay. Mr. Smith's position was different to Mr. King's position in that Mr. Smith had taken holiday during the term of his contract, but he'd not been paid for that holiday. And he has persuaded the Court of Appeal that the entitlement to holiday is a composite right to paid leave. And because his leave was not paid, he hasn't actually had his entitlement in accordance with the statute. So like Mr. King, his entitlement to holiday has accrued year to year, and he has a significant holiday entitlement. What's also interesting about Mr. Smith's claim is he didn't bring his claim under the Employment Rights Act as an unlawful deduction from wages claim. So he is not restricted by the 3-month break rule, and he's not limited by the 2-year backstop rule either. He raised his claim under the working time regulations, but he made a claim under the part of the regulations that provides for a payment in lieu of accrued but untaken holiday on termination of employment. Pimlico plumbers have had to pay Mr. Smith £74,000 for his accrued holiday accrued over the 6 years of his contract. So the takeaways from this are there are a number of employers with ongoing holiday pay claims, so they need to be revisited. The Court of Appeal, although it didn't need to decide the point in this case, has made clear that it doesn't agree with the finding in Bear Scotland that there should be a break, that the 3-month break rule applies. And there's also a High Court decision in Northern Ireland that agrees with that view. So it's that the 3-month break rule is up for challenge, and so that needs reviewing if you're relying on that in a defence. Claims also need to be reviewed to have a look whether they can be interpreted as making a claim under the working time regulations and not just the wages, the unlawful deduction from wages provisions of the Employment Rights Act. So if you're still in litigation, it's worth checking that. And it perhaps goes without saying that if you have got contractors whose status is uncertain as to whether they are genuinely self-employed or workers, that needs looking at perhaps more carefully now, because the potential accrued liability for unpaid holiday pay is perhaps more significant than we understood and not limited to 2 years. So that's holiday pay. I'm going to move on to talk about fire and rehire, just because this has become very topical in recent months. The fire and rehire tactic is a long-standing and potentially lawful means of achieving changes to terms and conditions of employment. It has always been regarded as a last resort, but it is a lawful means of achieving change. It's hit the headlines a little bit during the course of the pandemic, where employers were forced into a situation where they have had to introduce drastic measures to change terms and conditions to weather the storm. And more latterly, it's hit the headlines, unfortunately, as a result of the P&O Ferries scandal. That really wasn't a fire and rehire situation. It was more a case of you're fired, and if you want to still work, you can go and join an agency, because we're going to use an agency to get ourselves some cheaper labour. But nevertheless, it reignited the discussion around fire and rehire tactics. The risk for employers in using those tactics are claims of potential unfair dismissal, and also claims for failure to inform and consult if 20 or more employees are affected by the change in terms and conditions. Those risks can be managed as long as there is a good business reason for the change and the process that you adopt is a proper process. You can avoid liability. I think what has perhaps changed is there is also now a risk of reputational harm if you adopt these tactics. And so what do we need to be aware of? As a result of the backlash against the tactic in 2021, ACAS did do an investigation and they issued some guidance in relation to fire and rehire tactics. I called it a code of practice on my side, which is wrong. It's just a guidance from ACAS. And it's a best practice type statement. It emphasises that fire and rehire is a last resort to achieve changes to terms and conditions, and it emphasises the importance of information and consultation. None of that is new. There's no change recommended by the ACAS guidance, but it is a useful reminder of what is required. On the back of that, in February this year, the government announced that it had no plans to legislate in relation to fire and rehire tactics. On the 17th of March, P&O dismissed 800 employees unceremoniously, and that hit the headlines as a fire and rehire tactic, which technically it wasn't, but it was a very prominent issue in the press in particular. And a cynic might say that the government's about turn on the 29th of March 2022 in response to that was perhaps to gain some popularity for the government, but it has now announced that it will issue a statutory code of practice in relation to the law on this area. And the purpose of that code will be to bolster the enforcement provisions around the need to, in particular, inform and consult with employees in these types of circumstances. We haven't seen the draft code yet, nor do we have much detail about it, but the statement from the government was that employment tribunals will take the code into account when considering the issues in this area and whether the employer has adopted a reasonable approach. And to the extent that the terms of the code of practice have not been followed, employment tribunals will be able to uplift compensation payable to employees by 25%. The government says that the draft code will be published for consultation and legislation when parliamentary time allows, and we've all heard that before, so we'll wait and see when that might arrive. Just a final point on fire and rehire tactics. A case earlier this year involving Tesco and the union USDOR, and USDOR managed to obtain a declaration from the High Court and an injunction to prevent Tesco from engaging in this kind of tactic. It's a case very specific to its facts, which were extreme. Certain warehouse operatives at Tesco had been persuaded not to take redundancy payments during a previous reorganisation and given what was in effect a retention payment called a retained payment. And the language that had been used at that time in the collective bargaining exercise had all been around how this was a guaranteed payment for life and that it was a permanent award that employees would benefit for as long as they stayed with the company. And it was based on that language that the USDOR managed to persuade the High Court that there was an implied term in the contracts of employment of those employees that Tesco would not use a fire and rehire tactic to remove it. So very extreme facts, but an important reminder that if you are going to make changes to terms and conditions of employment, make sure you have a look at the origin of the term that you're trying to change. And if you are making changes, please be careful about the language that you adopt when you are persuading employees to accept change. That's all from me. I'm going to hand over to Patrick, who's going to take you on the home straight.
Hi everyone, I'm going to start by talking to you about bereavement rights. And it's a bit of a topic worth covering because it's often a little bit neglected, perhaps doesn't get coverage by HR practitioners. And there's recently been some ACAS guidance issued on this topic. So the first thing to be aware of are the statutory rights that people can bring to you when they want to take leave. First one is parental bereavement leave. It's been around since April 2020, and it's a right for certain employees, but not all employees, to have 1 or 2 weeks off work upon the death of a child. They've got to take that leave within 56 weeks following the death of the child, and they can take those weeks consecutively, or they can spread them around. There is pay available, again, not for everyone, but employees that have 26 weeks service, and if they're at least being paid the lower limit for national insurance purposes, they can get a statutory rate of pay. And it only applies to employees. There's no length of service threshold, so it's technically a day one right, but you do have to qualify as a bereaved parent under the rules to access it. So parent is quite wide there, so it'll obviously include natural parents, but also adoptive parents and people who are intended parents under surrogacy arrangements. There's no advance notice required in the first 8 weeks after the death. So all they have to do there is let their employer know when they intend to take leave, and really they just have to let them know before they start work that day. If that's not possible, they just have to let them know as soon as they reasonably can. So it's really quite flexible in the first 8 weeks. After that point, they have to be giving you 7 days notice of that leave. The employer has no control over the leave, and there's no rules for them refusing any requests or stopping it. And there's also protections generally to be aware of. So employees are expressly protected from suffering any detriment because they're taking this leave, but also from being dismissed because of it. So detriment could be things short of dismissal, like taking a bonus off them, or disciplinary proceedings. And if a detriment claim is successful, it's worth noting there's not just financial losses there they could access. They could also access the hurt feelings, the intrusive feelings there as well. So it is worth knowing they exist. The other thing as well is if someone has a right to the statutory bereavement pay and they're denied or not given that, they do have a remedy through HMRC where they can get that paid to them. The next type of statutory right to know about is time off for dependents, and this is in some ways more limited than parental bereavement leave, but in other ways a bit more flexible. And it's a right to a reasonable amount of time off to take necessary actions to deal with various prescribed situations that affect dependents. So it could include things like a dependent falling ill. It could involve making care arrangements for an elderly parent, for example, something along those lines. But in the case of a death and a bereavement, it really only covers practical sort of logistical matters like arrangements for the funeral and probate issues. So it's perhaps not as compassionate as the parental bereavement leave in its intentions. Again, it's only available to employees, not to workers, and it's a day one right for people. In terms of who a dependent is, it's quite flexible. I've noted down there the categories. It doesn't include grandparents and grandchildren, but if they do live with the employee, and there are certain other exceptions where they might qualify as dependents. An employer needs to be told as soon as reasonably practicable that they want to take the leave. There's no express notice requirement of a certain period they have to let them know. They just have to give the employer enough information so that they know they qualify for the right and how long they're going to be taking off. It's unpaid, and as I noted on the last slide, they've got the same protections against any detriment or dismissal for taking this leave or for trying to take it. So a few practical tips on what to do and how to handle them. Consider whether to go beyond the statutory rights. Obviously know what the minimum you have to do is, but I guess what you want to achieve out of this situation is that the worker returns to work healthy, happy to work, knowing they've been supported. So think about how you might be prepared to go beyond what the minimum is offered by the law. And be aware of discrimination risks. So there could be protected characteristics mingled in with what they're trying to do when they take this leave. So religious ceremonies, for example, doesn't mean you need to be overly afraid of that. It just means you need to be sensitive to that and build that into your decision making. There are specific rules around stillbirth, so that can trigger longer normal parental leave rights. So If there's a stillbirth after 24 weeks of pregnancy, or there's a neonatal death, you could have a situation where the employee is entitled to their full entitlement of maternity leave, and on top of that, they're entitled to their parental bereavement leave. So you need to be aware of what parental rights might trigger. That could include, there's rules for things like adoption leave as well, so it's worth considering each situation. And then I've just jotted down a few good practice elements here to, I guess it's good to have this process in place ahead of time rather than be reacting on the spot when an employee comes to you. There's ACAS guidance on this that's quite practical and useful, so it's worth having a look and maybe thinking about putting a process in place. The next topic I'm going to talk about is flexible working, and I think it's fair to call it a bit of a hot topic, particularly since the pandemic. I think we had a situation where overnight home working and remote working came into existence for a lot of sectors and businesses, and it hasn't really gone away. It's a theme of the employment bill, which is much awaited but does include flexible working protections being bolstered in it. And there's surveys and various articles and research floating around out there identifying that some, but not all, employees around the UK are feeling dissatisfied with the lack of flexible working options. This particular survey identified the sandwich generation, which is people in their 30s, 40s and 50s who are caring for their own children and at the same time are also caring for their parents in a lot of cases. And then just the statistics with the tribunal also back this up. Last year we had a 52% rise in tribunal cases that involved flexible working requests. So what are the rights? There's a statutory regime for formal flexible working requests that people can use. I guess the first point is perhaps the most important and one that's misunderstood by a lot of employees. It's not a system that obliges the employer to make changes, and it's not a system that gives them an absolute right for changes to their working arrangements, but it does place a certain level of formality to how the employer has to respond. It's not open to everyone, so only employees. It's not a day one right, so they have to have a certain level of service. And there are actually quite specific rules, if you're going by the textbook, as to what the request has to say, and it has to be in writing as well. It's worth noting that there's absolutely nothing to stop other people who don't qualify throwing a request in anyway, on an informal basis. You'll still have to apply a lot of the same principles that I'll come on to talk about. It's just that the statutory rules won't then apply to the situation. In terms of what the rules then do if they kick in, they place sort of a certain level of obligation on you as the employer. You need to act in a reasonable manner in the way you deal with the request, and you need to deal with it within 3 months, or you can potentially agree a longer response time with the employee that's brought it. And when you're refusing the request, it needs to be for one of 8 prescribed reasons under the rules. So these include things like the burden of additional costs on your business, difficulties with rearranging workloads amongst the rest of the team. So there's 8 of them there. Generally speaking, in practice, if you have a sensible reason as to why you can't do this, it tends to be quite easy to fit this in under the statutory rules. And in terms of the risks, so what if you get it wrong? What if you mishandle a request? Well, the statutory rules around the requests do have some consequences. So a judge, if there's found to be a breach of the rules by the employer, could order that they have to reconsider the request, but they don't necessarily have to then go and accept it. Or a judge can award a certain amount of compensation. So that can be up to 8 weeks' wages, but it's not necessarily going to be 8 weeks. It could be less if they feel the situation merits that. Unlawful detriment and dismissal, which we've spoken about. Again, there are those protections in place from mistreating people for trying to bring flexible working requests. Also dismissing them because of it. As with people trying to exercise statutory bereavement rights and time off for dependents' rights, if you're dismissing someone because of that, they can access not just an ordinary unfair dismissal claim, but an automatic unfair dismissal claim. That's the type of claim where it doesn't matter what length of service they've got, they can access that claim. And also, if you're found to have dismissed them, for that reason, it will be an unfair dismissal. So it's worth knowing that. Constructive dismissal, I've just noted there because, if a request is handled in bad faith or unreasonably, an employee might take that and it could be what triggers a constructive dismissal claim, which, for those that don't know, is the situation where the employee hasn't been dismissed, but they've taken the employer's behaviour as a breach of their contract of employment, and they've gone on to resign and bring an unfair dismissal claim off of that resignation. So the way you mitigate against that is by trying to follow the statutory rules and having reasonable procedures in place. I've also flagged discrimination as a particular issue because it's very often the case that the people that are bringing these requests have protected characteristics under the Equality Act. And they could be bringing them for a range of reasons. It might be that they have childcare commitments and they need to reduce their hours. They could be returning from maternity leave. It could be for religious reasons, if they don't want to work on the Sabbath, for example. Or it could be someone with a disability who is trying to make changes so that they can alleviate a medical problem. So it's looking out for those protected characteristics and knowing that when they kick in, you've got to be that much more careful around the decision you're making and your reasons. If you are, it's okay if you're going to accept a request, but if you're going to refuse one, make sure you've got solid business reasons for doing so. And I've just noted down a few features of discrimination claims here that, whereas the statutory rules for flexible working requests are so narrow, discrimination can be brought by workers as well as employees. There's a range of different claims that could be brought. One that is perhaps going to be quite common in a flexible working situation is where, if there's a practice of refusing flexible working requests in the business, the employee might bring an indirect discrimination claim. So that's where they're saying, you've got a policy of refusing these requests, and that's putting people with my characteristic at a particular disadvantage. So there's a few other factors there that I've jotted down that, again, under the statutory rules, if a judge is looking, have you breached the flexible working rules, they're not really going to scrutinise your decision. They're just going to look to see if you've hit one of the 8 reasons for refusing a request. Whereas in a discrimination case, your business rationale is going to be really, really important as to whether there was discrimination in the decision or not. So it's worth being aware of that risk of discrimination and just knowing that there's heightened protections there for employees if it happens. I've just noted down there that they're complex claims to deal with. The compensation is potentially uncapped, and also there's the reputational aspect of having a discrimination claim found against you. So how do you then deal with them if those are the risks? So know the statutory rules. I think, although I've kind of said that they maybe lack a bit of teeth, the statutory rules, there's a little bit of a compensation award there and they can maybe make you reconsider. That won't stop an upset employee trying to use that against you, and it's not going to reflect well in the tribunal if they're bringing other claims as well. Don't trip employees up on technicalities. So the rules for actually bringing the requests have certain criteria that needs to be hit. There's qualifying conditions. It might be that employees get those wrong and they haven't actually triggered the statutory rules. Generally speaking, it's not a good idea to then use that as a way of rejecting the request and trying to get rid of the situation. A, that's going to annoy the employee and it won't make their personal issues go away. And B, if they do later bring other types of claims like constructive dismissal and discrimination, it's not going to reflect well in front of a judge if the employer's been dismissive of a flexible working request and they've been overly technical in the way they've kind of got rid of that request. Demonstrate a serious and genuine consideration of the request. So yeah, I mean, your goal really is to, if you can accept the request, great, that's the easiest way of dealing with it. But if you can't, your goal is to try and keep your employee happy and satisfied. And you can do that by starting from a positive perspective and trying to think of the ways this request might work and almost work backwards. And if you do encounter issues, thinking of alternatives. And if you end up in a situation where you've kind of gone through that thought process, you've ruled out the request, maybe there's no alternatives either, at least by doing that genuine sort of frank exercise with them, that puts you in the best place to potentially keep them happy and help them understand that you're being authentic, you're being genuine in the way you're listening to them and considering it. Clearly explain the decision and your reasons behind any refusal. So this not only ties into, clear your minimum statutory obligations, so make sure you're hitting one of the 8 reasons for refusal, but more importantly, you want to make sure that the employee understands why it can't be done, and also so that if they do bring a more serious claim, like discrimination, for example, your decision and the reasons for your decision and how well you communicated that in a meeting or in a letter, that's going to be the foundation of your defence to any claim. So it's making sure that that business rationale is put across to the employee clearly. And then I've just dropped in, be consistent and maintain records. You'll often get employees talking to each other. They'll be aware of people who have certain arrangements in place. You don't want to be in a position where you've contradicted what you said 6 months ago to someone else. So if you're recording what you've done and what you've said, and an employee complains saying, well, John asked last year and he got this, you can explain why. It's normally that there's differences in the job roles, or there's distinctions that you can explain to them as to why someone else got it and they didn't, perhaps. And then I've just noted, consider a hybrid working policy. We've noticed just anecdotally an increased number of inquiries from clients about flexible working and about putting these policies in place. It can be a good way to get ahead of it. And if you're seeing a high volume of flexible working requests, to kind of get ahead of that and head them off. And I've just noted here, I won't go through this in detail, but it's just potential ways flexible working might come back onto the political radar and change in the future. There's different proposals out there. There's consultations that have concluded that could see a bolstering of these rights, opening it up to more people. And there's private members' bills that are putting pressure on the government to try and make improvements in this area. So it's something to keep an eye on. I'm just going to briefly talk about the employment bill. It was a big announcement in 2019 when it was brought in, and it was potentially going to solve a whole raft of employment issues that were coming up. It included changes for 0 hours workers after the Sports Direct scandal. During the pandemic, flexible working has come up again as a hot topic. It included extended protections for people on maternity leave, and it's faced a lot of delays, and no action has yet been taken since December 2019 on it. But it's recently coming up a little bit more, just as a general topic in the news around employment protections, particularly in the wake of P&O ferries and with the Queen's speech happening next month as well. In terms of what the bill includes, here are the key changes it would introduce. So flexible working would be a day one right, for example. Redundancy protections for women and new parents. So at the moment, maternity discrimination protections will end with maternity leave, whereas this would see that be extended for 6 months after the employee returns from maternity leave. And you can see there's a few others in there as well. There are a lot of reports that this is going to be left out of next month's Queen's speech and it won't be on the agenda for the government. But I guess we'll have to wait and see, because there's been a lot of pushback from that, from trade unions, from other politicians. So if it does make it onto the agenda, it's definitely one HR and employers will need to keep an eye on. And the final topic I'm just going to flag to you is obviously the changes that took place last month. I won't go through them because they're purely factual. So here we've got the COVID measures ending last month and the national minimum wage rates increasing. Increases to statutory payments, and we've got increases to compensation awards in the Employment Tribunal. And there's also, if you're in the room, you've got a note in your packs that will have these rates for you. And if you're watching online, there'll also be a file that we can give to you that set these out for you nice and neatly. In terms of what might be coming up in the future, just things to watch out for, there's potential proposals for this summer around more protections for disabled people in society generally, but it does also include some measures for the workplace, like introducing a new body that will offer training and development for employers, and also introducing something called an Access to Work Passport, which is a document that will set out in detail a disabled employee's medical condition. There's proposals for a new bolstered enforcement body for employment rights. So this would see multiple government agencies like the Labour Standards Agency, National Minimum Wage Enforcement, all combined into one to enforce those rules. And there's lots of outstanding consultations on interesting issues that are worth keeping an eye on. So, for example, a consultation as to whether restrictive covenants should be banned in employment contracts, And so we're yet to see next steps from those consultations, but it's worth keeping an eye out. So that's everything I wanted to talk about. I've breezed through the last few slides, but I'll be around at the end if you've got any questions. I'm going to hand you over to Joe, who's going to wrap up for us.
Patrick. So hopefully you found that helpful. As I said at the outset, for those watching remotely, if you've got questions, please do put them in the chat function and we will come back to you. But in terms of people in the room, any questions, comments, thoughts? Or have we been entirely comprehensive? I like to think we've been entirely comprehensive. We will be staying around. We will have some coffee, some more pastries. So if you do have any questions, you want to speak to any member of the team, then do please collar us at the end. Again, as I said at the outset, we will send the video through to all of you afterwards so that you've got that to share with colleagues. A mention while we've got you of our Myerson HR product, so our fixed fee retainer service. So if you want that reassurance of knowing that you have us on hand and that you can speak to us for any questions you want to deal with on an unlimited basis for a fixed fee, then please do, again, let us know if you're interested in that. It also includes our portal with enormous amounts of resources, template letters, policies, procedures, guidance notes, training materials. So again, speak to us if you are interested in that. Please do let us have any feedback. So the people in the room will have feedback forms. People remotely, we will send you feedback forms. It's really, really helpful to get that feedback from you because we can tailor each event to make sure it's as useful as possible for you. So thank you for that. We'll get another coffee, and it just remains to say thank you very much indeed for joining us this morning. Thank you.